afternoon, everyone. Thanks so much. Apologize for the delay, technology, you know. Anyway, thank you very much, everyone, for joining us. I think we had about 269 of you registered for this event. Legal issues in school nursing is certainly a very hot topic and has been in great demand. So I'm very pleased today that we have a couple of really excellent presenters to help you sort through these issues. First, I'll go through some housekeeping issues. We have two presenters today, and the first presenter will take questions after her talk. The second presenter will take questions immediately after her presentation. We will be doing a case study. So we'll move right into the case study, but I will be taking emails to healthservices@k12.wa.us. And so I will be scanning all of your questions this way so that, you know, if there's a lot of similar questions, we can make sure that those get answered. There will be a period to ask questions of Emma Gillette at the end of the case study period. So without further ado, I'm going to go ahead and welcome our presenters and introduce them to you. Calandra Sechrist, or Callie, as we affectionately know her here at OSPI, is the director of OSPI's Equity and Civil Rights Office. Prior to becoming director, Callie served as a program supervisor in the same department since January of 2010. She received her law degree from the University of Washington and provided legal services to at-risk youth and children in foster care while interning with Columbia Legal Services and the University of Washington Children and Youth Advocacy Clinic. Emma Gillespie, her practice focuses on defending people, businesses, and schools in civil litigation. She has more than a decade of school litigation experience and attended the National Institute of Trial Advocacy. Emma earned approval as a panel counsel for the Washington Schools Risk Management Pool in 2008. She has handled more than 100 school liability cases, which has involved representation of more than 20 school districts. Emma frequently presents to school administrators on issues related to FERPA and avoidance of liability in the school setting. She received her bachelor's degree in politics as well as a certificate in environmental studies from Princeton University in 1999 and graduated cum laude from Seattle University School of Law in May 2002. She was also named a Washington Law and Politics Rising Star in 2009, 2013, 2014, and 2015. Thank you very much, and take it away, Callie.
All right, let me see if I can get this working.
Hold the camera.
Oh, hold the content button?
Yeah, and shift towards the camera.
Oh, the camera.
There you go.
Well,
All right. Oh, there we go. All right, so I'm Callie Sechrist, and I'm the Director of Equity and Civil Rights, as Robin mentioned. And I'm going to spend the next half hour or so talking about how to avoid some of the top Section 504 pitfalls that we see, especially when it comes to 504 and its connection to school nursing. So just a heads up, usually our Section 504 trainings are about 4 hours long. So we are going to try to condense this and just provide you just some of those kind of top tips to take back and think about with your district teams on how to best integrate Section 504 into your nursing practices. All right, so I always like to start with this slide. This is the language from the Section 504 statute, and this is the basis for all things Section 504. It states that no otherwise qualified individual with a disability shall solely by reason of his or her disability be excluded from participation in, be denied the benefits of, or be subjected to discrimination under any program or activity receiving federal financial assistance, which I believe includes all Washington public schools. So I'm going to break that down a little bit. The first thing on there is that no student with a disability shall be or may be excluded from participation in the education program. So that's just a blanket statement, no discrimination, no excluding students because they have a disability. So that's the easy part. The harder part is when we talk about the benefits. So students with disabilities cannot be denied the benefits of any program or activity receiving federal financial assistance. And that benefits language is the reason that we provide accommodations and aids and services to make sure that students really get that equal benefit compared to their peers.
Someone needs to mute themselves, please. 114.
You guys
Thank
are
you.
not saying anything for slides.
Uh-oh, someone's not saying anything. All right, so hopefully you're seeing the slides. Otherwise, I will try to make the slides come to life for you. And anyway, all right, so the benefits language, the key here is that treating students the same doesn't necessarily always mean that students are really equally benefiting from their education. So that's why we provide those sometimes extra accommodations or extra services for some of our students to make sure they get that equal benefit. So the next key thing from the Section 504 regulations is that each school district must provide a free, appropriate public education to each qualified student with a disability. So this is what we know as FAPE, and there are a couple things I'm going to mention here. So first off is the word free, and the reason the word free is important is because it applies to everything from evaluations. All evaluations of students must be free or at no cost to the family. The services we provide to students and their families must be free. Any accommodations or other reevaluations are also free to students. So it's a free, appropriate public education. That next word there, appropriate, really means appropriate to the needs of the individual student. So in our world, typically students have very unique needs, very unique situations. Their disabilities might impact them in different ways. And so the Section 504 plan, or the accommodations or services we provide, need to be really specific to the needs of that individual student and appropriate to that specific student. So Section 504 can be very vague and very confusing, and this can cause a lot of frustration because a lot of times we want black and white rules. And in Section 504, there aren't a lot of those. I'm going to list out some of those very clear rules right now. But before I do that, I also want to point out that Section 504 is ultimately enforced by the U.S. Department of Education's Office for Civil Rights, also known as OCR. Here at OSPI, our Equity and Civil Rights Office is not OCR. So a lot of what we're going to be talking about are the regulations or guidance produced by the U.S. Department of Education's Office for Civil Rights. Anyhow, so if I mention OCR, that's what I'm talking about. So in the regulations or in OCR's guidance, here are the things that school districts must do. First, they have to designate a Section 504 coordinator for each school district. So hopefully you know who the 504 coordinator is for your district, and if you don't, you can find out. We have a list on our website. Many school districts also have Section 504 coordinators for individual buildings as well. School districts must also adopt complaint procedures for allegations of disability discrimination. In Washington State, these discrimination complaint procedures are outlined in our state regulations. So there are certain requirements that need to be in those complaint procedures that I'm not going to get at today. But usually these are located in your policy and procedure 3210. You also have to receive parent consent before the initial evaluation and initial placement. I'm going to talk about this more in a minute, but before that initial evaluation of a student to determine if they have a disability and if they need a 504 plan, and before actually implementing that 504 plan, make sure you receive parent consent. Schools also must notify parents in writing before taking any action regarding identification, evaluation, or placement. I'm sorry, the computer went to sleep. Uh-oh.
Excuse me, we're not seeing the slides in Candy.
Yeah, we're getting there.
We have not seen them at the beginning.
She's supposed to do the.
There we go. Duplicate?
Yeah.
Okay, cool, I got it.
Okay.
And then hit hit.
And then hit content. There we go. All right, are you seeing the slides now?
Nope.
All right, so
They should have copies
They're not seeing the slides?
on their hand or something.
Oh.
okay,
They should
so
have copies.
you
Okay, yeah.
should have copies at some point of the
Yes.
of the PowerPoint. So if you can't see the slides, you can reference them at a later point. So anyway, the next thing that schools must do is notify parents in writing before taking action regarding identification, evaluation, or placement of a student. So this is the prior written notice requirement. So it's as you're identifying students or referring students, before you evaluate the student, and before you implement the 504 plan. And at those same points, so identification, evaluation, and placement, those are also the same places where you are making sure to provide procedural safeguards to those families. So the procedural safeguards in 504 is usually a one-pager. Most of your school districts should have it, and if you don't, we have a sample on our website. And it notifies parents about their Section 504 rights and procedural safeguards. So you make sure to include a copy of that with that prior written notice before you take action regarding identification, evaluation, or placement. The next thing you have to do in 504, this is another one of those black and white areas, is make team decisions. We'll talk about that more in a minute, but team decision, bottom line, is more than one person. And then periodically reevaluate students. This reevaluation should take place at least every 3 years. All right, so now we're going to get into the 10 key points to remember about Section 504 to avoid the most common pitfalls that we see. All right, first is child find. So under Section 504, every school district has what we call a child find responsibility. And what that means is that the district is responsible for identifying or referring students for a 504 evaluation anytime you know or suspect that a student has a disability and suspect that a student might need accommodations or aids or services. So what's important here is that you can't wait for the parent to come to you with concerns, but that teachers and principals, nurses and counselors need to know that anytime you know or suspect a student has a disability and might need accommodations or services, the school district is responsible for making that referral and evaluating that student for a 504, determine if they have a disability and if they need accommodations or services. And there are many ways that you might know or suspect that a student has a disability. Because we're talking about school nursing here, one of the biggest ways to find out or suspect a student has a disability is if a student has a health condition or if a student has a health plan that is not a 504 plan. That is one way to determine a student might have a disability. We don't know yet, but they might, and so that might be a good time to refer a student. Or if a student is receiving home hospital instruction, is missing a lot of seat time because they are going to the school nurse's office a lot or going to the doctor a lot. Many reasons that you might know or suspect a student has a disability. So what is the definition of a student with a disability? I'm going to go over this really quickly. There are 3 prongs under Section 504 for students who are covered for non-discrimination protections. So this would be any student who, first, a student who has a physical or mental impairment which substantially limits one or more major life activity. I'm going to go through this more in a minute. Second is a record of having such an impairment. Or third is regarded as having such an impairment. But I'm only going to talk about this first one. So these other 2 prongs only apply for just general non-discrimination protection. So if you have a student who is harassing or bullying a student because they have a record of an impairment, that would be protected here. But the requirement to provide FAPE and accommodations and services only applies to this first prong. So a student who actually has a physical or mental impairment substantially limiting a major life activity.
We have an open mic. Everyone, please make sure you're muted.
And she wants me to do diabetic, which she
So she set all this up and
Uh-oh, I think someone's still not muted.
Moses Lake,
one should be done tomorrow.
we're not making any noise.
can you please mute your microphone?
Oh, yeah, that could have worked. I mean, it's weird because we switched.
Uh-oh, Moses Lake, are you there?
Moses Lake, can you please mute your microphone? Thank you.
All right, thank you. All right, so we're going to talk about this definition a little bit more here. Here's the definition we're looking at. And first we're going to look at substantially limiting. So physical, mental impairment that is substantially limiting on a major life activity. Substantially limiting doesn't have a great definition. It doesn't really have a definition at all. But there was some clarification recently with the Americans with Disabilities Act, Amendments Act. All it really stated was that To be substantially limited, it doesn't have to prevent or severely or significantly restrict a major life activity to be substantially limiting, which doesn't give us a lot of guidance. But what's helpful is to look at it as a spectrum. So some conditions might impact a student quite substantially, and some conditions might be less limiting on a major life activity. So if you have a student with, let's say, asthma, for some students, it might be substantially limiting on breathing, and for some students it might not. So it depends on the particular student. And next, it has to be substantially limiting on one or more major life activity. And this is a very broad list. I'm going to include the list on your screen. You should also have it in the PowerPoint if you have that on your computer or as a handout. And I'm going to read it out. It includes everything from caring for oneself, performing manual tasks, walking, seeing, hearing, speaking, breathing, learning, working, eating, sleeping, standing, lifting, bending, reading, concentrating, thinking, and communicating. It's a very broad list. And one of the things that was added with the Americans with Disabilities Act amendments is major bodily functions. And that's part of the reason why a lot of students who may be on health plans might also be eligible or might be qualified as a student with a disability under 504. So major bodily functions includes everything from your immune system, normal cell growth, digestive, bowel, bladder, neurological, brain, respiratory, circulatory, endocrine, and reproductive functions. It's a very, very broad list. So when you're determining whether or not a student has a disability under this definition, you're looking at whether a major life activity is substantially limited when the condition is active. So you might have a student who has, let's say, heat-induced asthma or migraines or a condition that's in remission. If, when that condition is active, it's substantially limiting on a major life activity, then that student does have a disability under this definition. The next change with the ADA Amendments Act is it stated that schools should be ignoring the effects of mitigating measures when determining whether a student has a disability. So when you're deciding if a student meets this definition of having an impairment that's substantially limiting on a major life activity, we are going to make that decision without looking at the student using mitigating measures. So mitigating measures are everything from medication, assistive technology, hearing aids, mobility devices, use of auxiliary aids and services, and it also includes, oh, that's okay. It also includes health plans. So health plans are considered a mitigating measure. So if we take away a student's medication, or we take away their health plan, or we take away their inhaler, are they substantially limited in a major life activity? And sometimes you're not going to know the answer to that because you don't know the student without their medication and you don't want to experiment by taking their medication away. But you might want to ask the student or ask the student's physician or their parents about how they were before taking medication or how it impacts them or how their impairment impacted them before they were on medication. I'm sorry, we're working on the slides here. All right, here we go. So mitigating measures can be a complicated thing. I'm not going to get into a lot of those details here. So I don't think you're seeing our slides right now, but I'm just going to give a couple examples. Let's say you have a student who has diabetes. What are some of the possible major life activities affected? Could be, let's say, functions of the endocrine system, eating, caring for oneself, thinking, walking, concentrating. Really depends on the student and how the diabetes impacts them. Is it substantially limiting? For diabetes, it's almost always going to be yes. Let's say a student has a food allergy. What are the possible major life activities? I think this one could be eating, breathing, especially if a student's going into anaphylaxis, functions of the respiratory system. And is it going to be a substantial limitation? And oftentimes it's going to be yes, depending on how severe the allergy is for a student. In the interest of time, I'm not going to go through the rest of these examples, but you do have examples in the PowerPoint if you happen to have that as a handout with you. Okay, so I'm going to go through a really quick case study. This is from a real OCR case. I'm just going to read it really quick. During her freshman and sophomore years, Lindsay was a straight-A student. She was class president and rarely got into trouble. At the beginning of her junior year, Lindsay was in a car accident, a serious car accident, and after taking a week off, she returned to school with a broken leg and bruises on her face and body. Since her accident, Lindsay's friends and teachers have noticed that her attitude and behavior have changed. She seems angry all the time and rarely turns in her homework. And she started failing her classes and was suspended 3 times within 2 months for behavior. So in this example, we often pose, what should the school do? And here, in this real OCR case, the main difference in the actual case was that it was a male student, and the student ended up dropping out before the school ever intervened. So in this case, OCR said that there was enough information to say that the school should have been on notice that something was going on. There might be a disability. There's enough information to say there could have been, let's say, a brain injury or something going on that is impacting the students' access to their education and whether they're benefiting from education. So we have behavior issues, change in personality. We have access to education issues because the student is misbehaving and is being suspended. And so in this case, OCR said, even without the parent sharing concerns or sharing any kind of medical diagnosis, the school district was on the hook for evaluating the student to determine if the student has a disability and might need accommodations or services. And my apologies, I know you're probably not seeing the slides right now, but I will do my best. I'm going to skip through some of this. All right, next key point to take away is that many health services are now considered Section 504 services. So because of the changes to the law with the ADA Amendments Act, many of the services provided under health plans, whether it's administering medication or providing other kinds of health-related services, can be considered accommodations or services for a student with a disability if those services are necessary for that student to receive a free and appropriate public education. And the bottom line here is without following the Section 504 process, a health care plan alone might not be enough. So the Section 504 process, which includes evaluation using a team, placement on a 504 plan, making sure you're getting parent consent, providing procedural safeguards to parents, this entire Section 504 process is really integral to making sure you're complying with 504. The process is really key. And without following that process, your health care plan is likely not going to meet the requirements under Section 504, and some of those services that you have in those health plans aren't necessarily complying with Section 504. So many of our school districts already have a process in place to integrate Section 504 into the health care plan process. There are a couple things you can do to identify which students might be eligible for a 504 plan. First thing I would think about is whether or not your health plan includes administering medication. If it does include administering medication, look at what the student's condition is, and it might be helpful to refer that student for a 504 evaluation at that point and then get your team together, even if it's just you and the parent, to look at whether or not the student's condition is a disability and then whether that medication is necessary for a free, appropriate public education. Also, does your health care plan include other accommodations or services? If you have a student with a food allergy, that could be desk washing procedures or hand washing procedures. Those kinds of things can also be Section 504 accommodations and should be on a 504 plan using the 504 process. So when making this decision on whether something should be a 504 plan or a health plan that's not using the 504 process, I recommend using these 2 questions to really guide your decision. First off, does the student have a disability? We already talked about what the definition of a disability is. If not, the student should not be on a 504 plan. If the answer is yes, the next question is whether or not the student needs accommodations, aids, or services to receive an equal benefit to their education as their peers, or to receive that free appropriate public education. And some of those accommodations, aids, and services might be outlined in your health plan, and if that's happening, that should be integrated into a 504 plan. All right, here's another quick example. Erin is a second grader and has a severe peanut allergy. Erin has a health plan to address hand and desk washing procedures, a peanut-free cafeteria table, classroom snacks, and EpiPen use. With a health plan in place, Erin hasn't experienced any issues at school because of his allergy. Does the school need to evaluate Erin under Section 504? So in answering this question, I want to go back to those two questions we posed before. So first, does Erin have a disability? Here we have a physical or mental impairment, being the peanut allergy. And is it substantially limiting on a major life activity? Probably in this case. Could be substantially limiting on breathing or eating. So once we know that Erin has a disability, next, does he need accommodations, aids, or services to equally benefit from his education? And in this case, the answer is probably yes. So we already have procedures in place in our health plan about desk washing procedures, peanut-free cafeteria, and other things. So in this case, the school should be evaluating Erin under Section 504, and perhaps that healthcare plan should be integrated into a Section 504 plan. There we go. All right, sorry about our technology issues. All right, in the interest of time, I'm going to go through this. 10 minutes. There we go. Okay, so we're on to number 3. Next key point to take away when we're talking about Section 504 is the importance of following the 504 process. I've already talked about this, but just a reminder that following the process is often the most important piece of 504. There's an assumption under 504 that this process is in place to make sure that our parents are informed and that with a team we're making proper decisions about appropriate services for our students. And this can include health services as well as other classroom accommodations or accommodations a student might need for field trips or to access the cafeteria, anything that impacts the student during the school day. So there are a couple key points in here to remember when you are evaluating students with health conditions that might also be served on a health plan. This process itself can be very well integrated into your healthcare plan process, but there are a couple points you want to make sure you're providing notice and procedural safeguards, including at this referral stage, at your evaluation stage, not only your notice and procedural safeguards, but also making sure you're getting parent consent for that evaluation. And when you develop and implement your Section 504 plan, you want to have notice and procedural safeguards to the family when you develop that plan, and consent before you actually implement the plan. And then when you're periodically reevaluating the student, which should be at least every 3 years, so you're probably doing that more often within your healthcare plan process, make sure you provide notice to the parents if there is a significant change in placement. And what that means is basically a significant change in the accommodations or services that you're providing to the student. All right, on to number 4. Number 4 is about medical diagnoses. Do not require a parent to provide a medical diagnosis. And a lot of times this comes as a big shocker. And this is something that OCR has been pretty clear about over the last few years. So if you remember when we talked about free appropriate public education, that first word there is free. So a lot of times parents will do this anyway. They will come to you with their medical diagnosis or medical information to help you with that process. And that is great. And you can ask parents to voluntarily provide this information. But if you have enough information either from the family or from teachers or other information that you suspect the student has a disability and the parent doesn't want to take their child to the doctor or isn't able to or can't afford to, the school district is on the hook for evaluating that student at no charge to the families, regardless of whether or not you have a diagnosis or not. And then it's up to the 504 team to decide if you have enough information to not need that diagnosis to move forward, Or on the other hand, if the 504 team decides it needs a diagnosis to move forward, the school district can then pay for a medical evaluation at no cost to the family. So one thing to keep in mind, I know a lot of our 504 teams are very concerned about diagnosing students, and that is not what we are asking our 504 teams to do. Rather, OCR has been pretty clear. I'm going to read a couple snippets from a couple OCR letters. In this particular case, this is a OCR decision in Rose Hill Public Schools in Kansas. OCR said, a parent may choose to use his or her own resources to obtain an evaluation or arrange with the district for reimbursement of evaluation costs. However, in no instance may a parent be required to arrange for and pay for such an evaluation. There's another letter, it's called OCR Letter to Veer, and this is where OCR says that we're not necessarily always needing a diagnosis for a 504 evaluation. If you have enough other information to show your 504 team that the student has an impairment, you might not need that medical evaluation at all. So here OCR says, if a school district determines, based on the facts and circumstances of the individual case, that a medical assessment is necessary to make an appropriate evaluation, the district must ensure that the child receives this assessment at no cost to the parents. But if an alternative assessment method meets the evaluation criteria, those methods may be used in lieu of a medical assessment. If a district does not believe that a student has a disability and refuses to evaluate the child, they must inform them of the due process rights. Anyhow, so if there are alternative ways to identify if the student has a physical or mental impairment and substantial limitations on a major life activity, you can do so without a medical diagnosis. All right, so in the interest of time, I'm going to skip this example, but it is in your handout or in your presentation materials, so you can take a look at it at another time. All right, on to number 5. The fifth key point to remember is that one person cannot make evaluation and placement decisions alone. So under 504, your decisions on whether or not a student has a disability and your decisions on what kinds of services or accommodations to provide to a student must be made by a team. And the team has to have someone who is knowledgeable about the student, so someone who actually knows the student, someone who is knowledgeable about the evaluation data. So as you're collecting evaluation data, whether it is medical information or assessment information, someone who can actually speak to the information that you're looking at and is knowledgeable about that information. And someone who is knowledgeable about placement options. And placement options include the accommodations or services that you can provide to a student. And that can include, especially for health conditions, of course, your school nurse. But a lot of times health conditions impact students in other ways as well. So it might impact their access to physical education, their access to sports or extracurricular activities or field trips. So having other people, including teachers or counselors, on your 504 team can be really important as well, even for students who have what look like pretty cut and dry medical conditions that might just need medication. It might go more broadly than that. All right, on to number 6. The 504 evaluation must involve reviewing information and data from multiple sources. This is also something OCR has been pretty clear about, that when doing the 504 evaluation, you can't just look at medical information. You have to look at information from multiple sources to decide how the impairment might be impacting the student throughout the school day. So that could include everything from, of course, medical information, grades or assessment reports, attendance information, or seeing how the student might be accessing their classrooms, or if it might be impacting their classrooms in some way. Again, it's really important to look at multiple sources of data. All right, number 7. Educational impact includes activities outside of the classroom. So sometimes our 504 teams are very focused on what's happening during the classroom, but 504 impacts addresses the student's benefit to the entire school day. So everything from going to the lunchroom, going on field trips, accessing sports and extracurricular activities, being able to interact with their peers. So anything that is social, emotional, impacting their school day in some way. And 504 can address the accommodations, aids, and services to address that entire impact on the student's education. All right, number 8, accommodations, aids, and services necessary for FAPE must be provided regardless of cost. And this can be really challenging because 504 does not come with any additional funding. However, complying with 504 is a condition to receiving any federal dollar at all. So if some services are necessary for a student to access and benefit from their education, the school district must provide them. So here's an example. Gabe is a 3rd grader with diabetes. His 504 plan includes assistance with glucose testing and glucagon administration from a school nurse. Later in the year, Gabe wants to participate in the school-sponsored science club that meets after school. Gabe's parents asked the school to provide the glucose testing and glucagon administration that Gabe needs to participate in this activity. The principal explains that the nurse is not available after school. So what should the school do? First question is, can the school deny the student's participation in this activity? And the answer would be no. And if we would look back at that 504, the statute in the beginning where we talked about not excluding a student because they have a disability, if we deny the student's participation, that would be excluding the student, so we can't do that. Can we ask the parent to come to school to administer the medication for the student? No, because it's ultimately the school district's responsibility to provide those accommodations or services. And so in this case, the school district has to find some way to provide this service for a student. And I think in this particular case, hiring a school nurse or finding some way to have a school nurse available after school to provide this service would be necessary for this student. So key points to remember here, provide any accommodations or services a student needs to participate in any school program or activity. I apologize, we're having tech issues again. There we go. Can you hit that button again? Oh, there we go, we got it. All right, don't deny participation based on lack of funds or staff availability. So there might need to be additional staff available for certain activities depending on the needs of the student. And remember, it's ultimately the school's responsibility to provide these services, not the parent. And on an individual basis, a school district can prohibit a student from participating if and only if it presents an unacceptable risk to the health or safety of the student or other students. So if this is an exception that you will be applying in your school for some reason, just be very, very careful because this is a very high bar to reach. First, you have to consider whether safe participation can be assured by providing accommodations or services. And if the answer is yes, you need to provide them. And if no accommodations or services would address the risk of health or safety to the student, just make sure you're documenting why exclusion is necessary, and consider if there's another activity you can provide that's more inclusive to all of your students. All right, number 9, does everyone know the student's 504 plan who needs to know? A lot of times our substitute teachers aren't always aware of our students' 504 plans. So making sure that substitute teachers are aware of our 504 plans. Depending on the student's participation in sports or extracurricular activities, sometimes your coaches, your PE teachers, extracurricular folks might need to know that student's accommodations or services. And if the student is going on a field trip, making sure that the bus driver or other adults who are on the field trip with the student know if the student has particular health services or accommodations that might be appropriate or necessary to provide in that environment. All right, number 10, finally. I'm not going to go into this much, but before you suspend or expel a student, or before your principal or assistant principal suspends or expels a student, just know that all students with disabilities, whether it's under IDEA or Section 504, any student who meets that definition as a student with a disability has certain protections when it comes to suspensions and expulsions. This can include students with food allergies or students with diabetes, a lot of students that we wouldn't necessarily consider doing a manifestation determination for. We have to provide under Section 504, very similarly to under special education. So, not going to get into the details on manifestation determination, but if you have questions on that, feel free to contact us and we'd be happy to walk you through that process. So we have many helpful resources here on our website and on OCR's website that you can check out to learn more. And our contact information is here on the screen. If you want to call us or email us anytime to walk through some questions, we'd be happy to talk with you. In case you don't have the PowerPoint up, our phone number is 360-725-6162. Again, that's 360-725-6162, and we'd be happy to answer your questions. So I'll pass it on to Robin for a minute.
Yeah, so I think we can probably take questions for about 5 minutes. We do have one question here. Callie can read that and respond to that, and then if you can send an email to healthservices@k12.wa.us to indicate you have a question, we will open up the mic for you.
All right, so we have one question here. It says, what is the obligation to notify parents of the student's possible eligibility for 504 if, for example, a parent notes on the health questionnaire that her student wears glasses? This is a really good question. So one of the things that I forgot to mention when we talked about mitigating measures is that's one of the few areas where there is an exception. So eyeglasses and contact lenses are not considered mitigating measures. So if a student can see okay and is able to access their education with the use of eyeglasses or contact lenses, then that student would not be considered a student with disability for that reason. However, let's say you have a parent who is notifying you on the health questionnaire that their student has diabetes or has a food allergy. That would be a time where I would certainly recommend notifying the parents that their student might be eligible for 504, giving them a copy of their procedural safeguards, and then referring that student for a 504 evaluation.
Thank you. So I'm not getting any questions on email, so I think what I'll do is just do a round robin. Are there any questions from ESD 123, Pasco?
I do have a question.
Any questions?
I have a question.
Ask it.
Okay. My question is how does this,
Can you speak up, please? We can't hear you very well.
who do I talk to?
It's in the ceiling.
I'll look up. How do we go about enforcing the Senate House bill that we can exclude students with health conditions until we have doctor's orders? And how does that relate to we cannot exclude students from their right to education with these kind of plans?
That's a very, very good question. And sometimes we will see federal law and state law conflicting in places. This might be one area where I would like to confer with my team and do some research before getting back to you, just to make sure that we are all on the same page and provide you the best information we can. So I will go back and do some research, and then I will talk with Robin, and then we can give you some information.
Thank you. Any questions from ESD 113? Tumwater.
Yes, so what about for disabilities that are going to be very short term, like a broken arm?
That's another very good question. There is no very specific rule on the timeline there. Here is my rule of thumb. If you have a student who has a condition that is likely to outlast your 504 process, that's when I would work through your 504 plan and your 504 process. Because sometimes you might have a student who has a broken arm that is going to take a lot longer to mend, and sometimes you have students who might be very quick to mend. And we've had times where a student has broken his writing arm and then had to go through physical therapy, and it was a very complex, I don't know the term, but basically complex break, and it actually did take 6 months or longer to for the student to really get back to writing with his writing arm. So my rule of thumb is if it's likely to outlast your 504 process, go through your 504 evaluation. But if it's likely to address itself or to be resolved before that process is going to be completed, I would recommend going through your healthcare plan process instead and documenting why you didn't go through the 504 process.
Any questions from ESD 171, Wenatchee?
Oh, someone else.
Oh, one more question
Wait.
from 113.
No, well, we have many more questions, but I guess we can't occupy all the time.
Yeah.
Okay.
You can save the questions also for later, and Emma may be able to address some of those.
Okay, that the 50 replaces the IHP, that you only need the one document. But I don't hear that advocated today, that there is an IHP, and then that might stimulate the 504 process, and it's really two separate documents. Which is it?
So school districts might do it in different ways, and partly it depends on how your school district uses health plans. Sometimes school districts use health plans in a way that almost all, if not all, of their health plans are 504 plans, and then a lot of times our school districts will label them that way. It'll say Section 504/health plan. However, some school districts use their health plans for things like if a student has mild menstrual cramps and needs ibuprofen now and then, sometimes our school districts will use a health care plan to outline that the school can have, or the student can have ibuprofen if they come to the school nurse's office. In that kind of situation, sometimes health plans aren't actually 504 plans because the student doesn't necessarily have a disability or doesn't necessarily need that service to access FAPE. So I would recommend that if the student needs certain services to access FAPE and it is a student with a disability, that should be a Section 504 plan. And you can label it a 504 plan and a health plan, but ultimately it's a 504 plan. If you have health services that you're providing that aren't for a student with a disability or aren't necessary to address a student's access or benefit to education, I would recommend not having that a 504 plan and labeling it differently. But it partly just depends on your own district's process.
Okay. Thank you.
Okay. Yeah, thank you.
ESD 171, Wenatchee. Any questions there?
Yes, there is a question. I actually was excited to learn that it sounds like any student or any school that has a student with diabetes that has glucagon in that school needs to have a nurse there all the time. So it looks like our nursing staffing is going to be tripled or quadrupled here pretty quick. That's exciting.
Is that how you would interpret that, Callie?
So Robin asked me if that's how I would interpret that. I am not going to make any black and white rule on how schools staff their nursing. However, if a student needs administration of any medication by a school nurse, the school district has to provide that service. And whether or not they provide nursing services full-time or not, or whether or not a school can place students with diabetes in a particular school to provide those services in one central location. I'm not going to get into those kinds of examples, but there are other ways that school districts can address that. But they have to get the services they need, and there might be some creative ways to do that.
Okay. How about ESD 189, Anacortes?
Hi, Robin. No questions here at this time.
Thank you. ESD, or how about Kent? Any questions from Kent?
We have 3 questions for you.
Okay.
If a parent refuses 504 protections, how often do we have to re-offer, like for a student with diabetes?
It's a really good question. I don't know that I've seen any blanket rule on timelines there. I know that there is an ongoing child find responsibility. So that might be another one that I go back and do some research on. I think at the very least on an annual basis is probably a good idea. But I don't know if there's any clear guidance on that. But I would recommend at least on an annual basis and document that you did make that attempt.
So,
I agree with
question,
Callie. I
but
don't
what
think
if
that there's
the
any
parent
clear
does not
guidance
give
on the
consent,
issue, but probably at least yearly is a good rule of thumb.
Oh, sorry.
Thank you. Other questions, Kent?
I'm sorry, we didn't hear that because I was trying to ask a second question. I didn't realize somebody was talking back there.
Oh, okay, go ahead, Emma.
Oh, I was just saying that I agree with Callie's general response, which is to say I don't think that there's a lot of clear guidance on that, but I do think that, I mean, off the top of my head, I would say that at least every year is a good rule of thumb to go by.
Thank you.
Great.
On a related topic, what if a parent does not give consent, but you think the student needs the assistance?
So there are a couple options for that. We've seen schools do this in different ways. Sometimes parents will not want to consent for a 504 plan, but would consent to having services on a health plan. We haven't weighed in on whether or not that's okay or not, as long as it's not on a 504 plan and a parent hasn't consented to the 504. We are likely not going to be, at least in our office, we're not going to be monitoring school districts on whether or not you're providing services on a health plan with the parent's consent versus a 504 plan. So bottom line, if a parent doesn't consent for a 504 plan, you can't implement a 504 plan. However, you can talk with a parent about what 504 is, the intent, and if the parent consents to a health plan instead of a 504 plan, I would just be very careful to document that process and document that you provided the parent a copy of their procedural safeguards when they made that decision. There's not really a black and white answer on that either. If, let's say, many schools are using 504 plans for, classroom accommodations that wouldn't be on a health plan. So let's say you have a student with ADHD that needs, some substantial accommodations in the classroom. If you have a student or a parent that is not consenting to a 504 plan in that case, the school district has the option to initiate a due process hearing, a 504 due process hearing, to override the parent's consent. You also have that option for health plans as well, though with health-related 504 services. But at least in that case, you kind of have another option you can use, which would be your health plan instead of a 504 plan. But in all cases, the district does have the option to attempt to override the parent's consent by going through a due process hearing, but that's pretty rare.
So we do need to move on so that Emma will have enough time to present. Those of you
Puyallup didn't get to ask.
Those of you who were not able to ask questions, please email those questions to healthservices@k12.wa.us. I will compile those questions, and if we don't get answers for you today, I will make sure that we do get them and email those out to you.
Robin,
yes?
Robin, does Puyallup have a chance to ask one question?
We are moving on now. If you can please email that question, I will make sure that Puyallup and Spokane and ESD 112 have the first opportunities to answer questions at the next question period, so that you get to go first when Emma is finished with her presentation. And again, you can email your questions to healthservices@k12.wa.us, and I will be collecting those and responding to all of those. So thank you very much, Callie, for your presentation.
Absolutely. Thank you very much.
And with no further ado, Emma Gillespie.
All right. Good afternoon, everyone. Thank you for joining us for a little information on risk management from the nursing side. So just in terms of the focus of what I want to talk about today, it's been my observation that nurses in general You play a really important role in maintaining the health and safety of our students, and you also, because of the nature of your position, your position poses some unique challenges, especially from a risk management standpoint. You are in a position where a lot of times you are professionally isolated. You may be the only nurse in the district. You may have, you may have several, but the fact of the matter is you're not at a hospital. You're not in an institution whose main purpose is providing medical care. So that can result in some isolationism for you guys. You've got a wide range of responsibilities, and you probably have a supervisor who is not a medical professional. And then you also get the dubious honor of needing to comply with multiple sets of rules and regulations from both the medical health standpoint, and then also there's a set of rules that applies to school districts and education law in general. So you have the responsibility of knowing what the federal, state, and local rules are that apply to you in both contexts. So perhaps unsurprisingly, that can give rise to some potential exposure for risk. And I want to talk about some of those, some of the main areas that I've seen where there are potential pitfalls. And I also want to talk about things that you can do, hopefully, to avoid that risk. So we're going to talk about we're going to talk about two, but really there are four main keys to managing risk from my viewpoint. The first is staying up to date on continuing medical education and standards of care. That's outside the scope of my expertise. We'll talk a little bit about that in terms of statutory regulations, but that's more in your wheelhouse in terms of staying up to date on that. The second thing is establishing good working relationships with students and families. I can't tell you how many times we get a case, and it's not necessarily the substance of what either a nurse or anyone else at the district has done, but it's how that instance was handled and what the relationship with the parents is like. And do the parents perceive that you as an individual cared about their student? So that's a big deal, is establishing those good relationships and having good communication with the families. And then the third thing that we will talk about today is staying up to date on state and federal laws that apply to school districts. And then also, you will hear this until I am blue in the face, but documentation. Document everything. So, and we'll talk about some of the areas where it's fairly obvious that you need to document, and some of the areas that I think are a little more, or sneakier areas. So, I want to start off with some examples, some case studies that, well, not case studies, but they're actual cases that have occurred that provide an example of areas where there's potential exposure. So the first one, this is a case, it happened in 1998, so it's an older case, almost 20 years at this point, but it still applies today. So in that particular case, we have a student who comes into the health office, is having difficulty breathing, and the nurse does not make an assessment of the student's condition. Also importantly, doesn't document that visit. So insofar as the nurse did do any assessment, we don't have any written documentation of that. What is not on this slide but happens, so student gets sent back to class, and lo and behold, student comes back to the nurse's office, and on the second visit, nurse still doesn't perform a full assessment and doesn't document that second observation. Provides another student's asthma medication, red flag number 3, right? And sends the student back to class. Oops, I forgot, I thought I had one more bullet there. But end of the day, the student ends up dying, and it's a tragic situation. And again, two issues. The first is the failure to assess and recognize the need for emergency care. The other is that we have a situation where even if the nurse had conducted appropriate assessments, there's no documentation. So at best, you have a nurse saying, well, this is what I remember, and I think I did these things. So assess, treat, document. Really, really important. So in that case, the court did find that the nurse didn't meet the required standard of care for failing to, because she failed to recognize the need for emergency care. Okay, second case, and again, failure to recognize the need for care. And this is, unfortunately, it's a local case. It's really sad. I admit that when I first read the court's opinion on this relating to the liability, that I was a little weepy at the end. It's a really sad case. So this was back in 2001. We've got a Spokane school district class that has headed out on a field trip, and we have a student with a known peanut allergy. On the field trip, in addition to several volunteer parents, we have 2 nurses, a teacher, and they have an EpiPen, and those are all really relevant factors for this. All of the students receive a sack lunch, which includes a peanut butter and jelly sandwich, a bag of mixed nuts, and, oh, by the way, a peanut butter cookie. So fail number 1, right, is the district knew that this student had an allergy, and somewhere between the folks who made the lunch in the cafeteria and sent those on, there was, the ball was dropped, and so we have known allergens in this kid's lunch, and presumably very little else for this student to eat, right? So student diligently looks through the lunch, says, I can't eat this sandwich, I can't eat these nuts, doesn't recognize that the cookie is a peanut butter cookie, takes a bite, and starts having a reaction. So that's our first big evidence of negligence. Second issue. So now that we have a student having a reaction, what do? Well, the student gets put on the bus to wait for an hour until the class is done. We know that falls below the standard of care. Student's condition deteriorates, so they decide that they're going to all return to the school. I suppose better late than never. The school bus decides they're going to take the student home, but as the student's trying to get off of one bus and onto the other, the student passes out, he collapses. And it's only at that point that they say, hey, this kid probably needs some immediate medical care. So they don't call emergency services, they put him in a car, and it's in the car that they first issue that epinephrine. So that's the first time that this student receives any medical care. Now, granted, this case was back in 2001. I think we have better knowledge of peanut allergies and how severe they can be. But the point of this is, when you have this type of condition, you have to act immediately, especially with a known allergy. The other thing I want to bring up with this case is the fact that, before I move into the more recent legislation on EpiPens, I did want to point out that liability in that case, not surprising that the court found liability. Total exposure to the district back in 2001 was $960,000, plus a $25,000 donation to the Food Allergy and Anaphylaxis Network. So add some legal fees in there, and that's a pretty hefty bill for the district. Concerning is the fact that we've got 2 nurses on the bus with the student and an EpiPen, and the EpiPen is never administered. We do have current standards now that direct nurses to inject an EpiPen at the first sign of anaphylaxis. I'm sure everyone that is listening knows that. And then as of 2013, Washington law does require schools to carry EpiPens on hand. School nurses can administer the EpiPen if there's an allergic reaction, whether the student has a diagnosis, an allergy diagnosis or not. However, if a student does not have an allergy diagnosis, it is the nurse that has to administer it. You cannot have somebody that has been trained to administer an EpiPen administer in that situation. And fortunately, so it's RCW 28A 210-383, but that statute also provides immunity for school nurses who inject the EpiPen. So that's the good news. So when in doubt, my suggestion is to go ahead and use the EpiPen and figure out what needs to happen after that. So new legislation, be aware of it. All right, next case. So we've gone over a couple of failure to prevent and failure to provide emergency care. This situation, we have, it's a more recent case, Florida 2012. This action is actually still pending. So the student shows up to school with an inhaler. It's sealed. It has his name on it, complete with the medical prescription. And he has a known condition. The school knows that he has asthma. Hasn't filled out the paperwork, is carrying the inhaler with him, and I know that inhalers are a big issue for you guys right now. Principal says, you can't have this in school, it's contraband, and seizes the inhaler. So there are a lot of ways to handle this situation. This is not the one that I would recommend. Because student then, what do you know, ends up having an asthma attack, and we now have a lawsuit that where the parents are suing for damages. And is this for certain a case of negligence? I can't say for certain, but I think it's likely. We have a situation where there are a lot of other alternatives to the principal seizing this inhaler that don't involve removing what can potentially be life-preserving medical care. So one more, and again, this is a situation where probably a call to the parents is what needed to happen rather than just seizing the inhaler as contraband and denying the student the ability to use that medication when it was clearly prescribed to him and was addressing a condition that the district knew about.
Emma, may I just interrupt for a moment? We've gotten a couple of comments here from nurses that say that we're not required to stock epinephrine in schools. The bill that you were referring to, I think, allows school districts to stock epinephrine, and school nurses must administer to undiagnosed students, but they can delegate to unlicensed personnel administration of epinephrine to students who have a known anaphylactic allergy.
Interesting, because I understood that to require the district to have it on hand.
No,
okay.
It allows.
My apologies for the misunderstanding. I do know that there are a lot of districts who have had issues accessing epinephrine when they don't have a student who has a diagnosis and they are wanting to have it on hand in case they need it, but they don't have any student that has a prescription, so they're having a hard time getting it from doctors. So, all right. Moving on, we have another issue where, so the issue in this case, we'll go ahead and get this started, is not necessarily a failure to provide medical care, but it was a failure to follow the district's policies, their own internal policies. So this is back in 2002. We have a student who had a severe case of asthma. And the school's policy required that medications be kept in the school office. Student keeps the asthma medication in the school office, has an asthma attack, comes to the school office, and is administered the inhaler by a health aide who had been trained in how to administer, but the student still died. The issue in this case was that the district did have a policy that said, yes, medication should be kept in the school office, but there was an exception to that policy that would have allowed him to carry his inhaler, and nobody informed the parents about that. So when I look at that, to me, that's a big red flag that says that that was a nurse that wasn't completely familiar with the school's policy, or worse, was familiar with the school's policy and ignored the school's policy. And particularly in a case where you have a student that has known severe asthma, that's problematic. So, all right. So we've covered failure to follow policies. We've covered failure to administer emergency care when we need it. I'm going to talk a little bit about delegation. And this is a case, so this was an Oregon case, and at the end of the day, the nurse lost her license for in this situation. So what happened was we had a student who had spina bifida and required catheterization, and the principal delegates to a para and says it's going to be your responsibility to change the catheter for this. Para says, whoa, wait a minute, that's outside the scope of my job duties. I am not comfortable with that. So the paraeducator sued for an injunction and was successful in getting the injunction, and the courts ended up referring to the Oregon Board of Nursing for a formal opinion on the delegation issue. And conclusion by first by the Oregon Board of Nursing and then by the court relying on that opinion was that, first of all, the principal was inappropriately practicing nursing without a license. And the reason that's relevant to you guys in the room is this is a situation where you've got a student with spina bifida. Presumably the school nurse knows about this situation and presumably knows that the school principal is delegating in this manner. I don't think you get to a point where you have a paraeducator that's requesting a TRO, a temporary restraining order, without the nurse being aware that that's the situation. So that's the first issue, is you have the nurse allowing the principal to make this delegation. And then the other issue is that, at least in Oregon, the paraeducator was not in a situation where it was lawful for her to be changing the catheter. So that's a little different in Washington, but the point remains that if you have something that cannot be properly delegated to a health assistant, you as a nurse need to make sure that that's a task that is being taken care of by you and not by anybody else. If you do delegate, two big issues. First, you have to provide training. So do provide the training, first of all, and then the second issue is document that you have provided that training. So it's not enough, I don't think, just to do the training. For your own protection as a licensed nurse, my recommendation is that you make sure that you are very careful about documenting what kind of training you provided when you delegate something. So, yeah, and then this is just setting out exactly why the nursing board was unimpressed. They said, first of all, nurse, you failed to follow standard of care, and second, they conducted a nursing assessment on the appropriateness of delegation. So, all right. So we've talked about delegation now. We're going to move on to searches. And specifically, we're going to talk about two different types of searches, both of them unreasonable. This first one is Safford, and, well, actually, we refer to it as the Redding case. But this one made it all the way up to the U.S. Supreme Court, which is a big deal. So in that particular case, we have a student who goes to the assistant principal and says, hey, this other student gave me a white pill. And So assistant principal says, okay, that's not how we do things. That's against school policy. So assistant principal searches the student's pockets and finds a blue pill. So then in follow-up, assistant principal has the school nurse along with the administrative assistant search in the student's bra and underpants. So on the one hand, good job having somebody else there if you are going to conduct a search. Downside is this is a really invasive search for when the only evidence you have is that you have a white pill and a blue pill. So turns out the pills were over-the-counter naproxen and ibuprofen, which it was a violation of school policy. But the student who had been searched, so we're talking bare breasts, we're talking bare pelvis, really invasive search. Supreme Court of the United States concludes that this search unreasonably violated the student's right to privacy. First of all, because based on the nature of the drugs, there was no indication that this was a significant danger to the students. And the second issue was they didn't have any reason to think that this student was stowing extra drugs in her uns or in her bra. So the point being, you've really got to think hard about why you're doing a search and what your requirements are. Uh-oh. Robin, we lost our feed.
Sorry.
It's okay. Just 1 minute. We'll be back on it. Perfect. Thank you.
Come right back.
All right. Great. So the upside for the nurses in this case were that the standard for what constitutes an unreasonable search that violates the student's right to privacy was unclear. So they granted immunity to the nurse and to the school. But for our purposes, the important thing is that we now know that this is an unreasonable search. So insofar as this happens a second time, I doubt that either the school or the school nurse will receive immunity in that situation. So, all right. So that's our first unreasonable search. Was we're looking for something on a student's body. The second is a search in terms of attempting to diagnose a student. So this is a Tennessee case, 2013, and we've got a 6-year-old who comes in to the school nurse and complains of genital itching and discomfort. And so teacher calls the parent. Parent responds and says, yeah, I think that's probably just her UTI. She has chronic UTIs. It's probably just her UTI. I'm going to take her to the doctor tomorrow. Student comes to the school nurse the next day, clearly has not gone to the doctor, still complaining of the same symptoms. So nurse, who did not know the student's medical history, decides to go ahead and conduct an examination. So nurse takes the student into the bathroom with the secretary. Again, good job getting somebody else to come with you if you're going to do such an inspection, but has the student remove her pants and her uns for a visual inspection. All right, so nurse is reprimanded for failing to send the student home per the school policy when they can't reach a parent. The other issue is parents are suing for an unreasonable search. And conclusion is, I'm not sure if I have another, yeah. So the court concludes that this did depart from nursing standards because there was no emergency situation requiring this kind of an invasive examination. And before you guys go thinking, man, what was this nurse thinking? I want you to know that about 2 years ago, I had almost this exact same case. So part of the issue was, in terms of departing from nursing standards, this examination is not going to help a nurse diagnose a UTI. You can't do a visual inspection and decide that a student has a UTI. And the second issue is there was no reason to think that there was bleeding, suspicion of bleeding, or suspicion of child abuse. Talk to the parent. We know that the student has recurring UTIs. Student hasn't given any evidence that there has been sexual misconduct. Search is inappropriate, and that's going to lead you to exposure both as a nurse and for your district. So, all right, moving on. In this case, we've got an issue of, well, I'm going to start with the failure to follow health standards, and then we're going to get into when parents are expressing their opinions about how medical care should be provided and their preferences. So this first one was in 2007, District of Columbia. We've got a kid with CP, and she's in physical distress throughout pretty much the entire day. She comes in, the school nurse does assess her, but rather than doing a full assessment and deciding to get medical care right then, school administration can't get in touch with it was a foster mom, but couldn't get in touch with the foster mom, and sends the student home on the bus with an urgent health note. So student gets home. It's an hour to an hour and a half bus ride home, and by the time the student got home, the student was dead. And we have a situation where, actually the foster mom never found the urgent health note until for several hours. It was in the bottom of the student's book bag. But a really sad case where you've got an issue where you're waiting for parent input, and rather than just proceeding on your own gut on what you should do, you are trying to get the parent's input in terms of medical provision. So that's the first case, which leads into the second case, which demonstrates this a little clearer, which is this was actually in 2014, so just last year here in Washington, and we've got a parent who wanted the school to call her instead of the hospital. So nurse does that. Student goes into anaphylactic shock. Parent says, no emergency care, I'm going to be right there. She shows up. She tries to put her child into the car, and her child stops breathing in the car. And so the student did end up dying. And the point is, when you're in doubt, call 911, call emergency services. The backlash that you will get from the parent for calling emergency service compared to the litigation that you might be involved in because you failed to call emergency services, that it doesn't even compare. So other take home is, if you have a health care plan, make sure that you follow the health care plan, no matter what no matter what the parents say. Sorry if I don't move.
Here we go again.
Yep. We're going to get good at it, though.
Get really quick.
That's right. Oops.
There you go. There we go.
And then, yep. Okay. There we go. All right. So here's another potential. This is a situation where I don't mean to be all doom and gloom. Here's a good situation where nurse went with her instincts and turned out for the better. So we have a situation where this is 1998, and a Missouri nurse gets a prescription from a doctor that says you need to administer this exceedingly high dose of Ritalin. I think it was like twice the recommended dosage. Yeah, and that was according to the physician's desk reference, so an objective measure, right? So nurse refuses to administer the Ritalin per doctor's orders. Parents say that's a violation of the ADA and Section 504, and you're discriminating against my child based on my child's disability. Court concludes that it is not disability discrimination because the policy was neutral and applied to all students, i.e. the nurse was applying the same medical treatment and standards that she would have to any other student. So the point being, this is a good situation where a nurse was able to shield herself from potential liability down the road when the parents come back and say, hey, this doctor really screwed up, and you, nurse, you should have known better too because the physician's desk reference says otherwise. So, all right, so nursing in the media. We've gone through a whole bunch of situations. Now I want to talk about sharing information, and you guys know that this can be a little bit of a sticky wicket in terms of making sure that you share the information with all the people who need to know, but none of the people who shouldn't know. So that can be a tough decision sometimes. So we'll talk a little bit about situation, just this situation generally. So first of all, we share this type of information with the folks who need to know. So who needs to know? Basic standard, when it's necessary to protect, when the disclosure is necessary to protect the health and safety of the student, you should share it. So if you have, second impact syndrome, big deal right now, right? Has been for, I would say, the last 10 years or so, but especially in the last 5 with the Lystet law. And we have some changes to that more recently. So if you have a student who you know has suffered from a concussion, you need to make sure that both the coach and the PE teacher are aware that this student has had a concussion, so you don't have a return to play situation inadvertently, because there are a lot of times that students are injured with a concussion and they don't want to sit out. Playing in PE is fun, playing soccer is fun, playing football is fun. They want to get back on the field and they want to play, and especially with a head injury, sometimes the consequences or the symptoms of that can be sort of hard to really understand. It's not like a broken arm that hurts. It's not like a strained muscle that keeps you from playing. It is more of an esoteric type of injury. So that's the first situation where we want to talk about sharing information. A lot of health conditions need to be shared with your special education teachers. I would say it's tougher to figure out a health condition that the special education teacher would not need to know about than it is to figure out a health condition that they would need to know about. I think most of the time special education teachers fall under the need to know category. Allergies, we talked a little bit, we talked about that Spokane case. Really important that anyone who's supervising lunch aides, teachers, that those guys are all aware of any allergies that a student might have. Someone who doesn't need to know, you've got somebody who's got a sprained arm, that sort of thing. In terms of, I don't want to get ahead of myself, so we'll go ahead and we'll keep going. So I think we've got one more example. And going back to the second impact syndrome and reporting, we've got a lot of cases where you've got a student who unfortunately, where they've suffered a concussion and then have come back to play and have died because of having that second impact. So that's just one good example of where communication with coaches, PE instructors is going to be really, really important. So this is our last example, and we have, as nurses, you guys are mandatory reporters. I know all of you know that. This case was a 2007 case. We have a nurse who was charged with a crime because she failed to report child abuse. The child died and her parents were charged with murder. And just a good reminder that under RCW 2644-030, you really need to report whenever you have reasonable cause to believe that a child has suffered abuse or neglect, which comes in a lot of forms. It can be physical, it can be sexual, any of those things. But do remember that when in doubt, my suggestion is to report. You are entitled to immunity when you are reporting with good faith. So even though it can make some parents really angry, I'm still dealing with some Public Records Act requests from a set of parents who were really upset about the fact that that somebody reported as a mandatory reporter, and they also feel like the district is spending what I would say would be like 80% of their budget spreading bad rumors about the parents. But the point is, no matter how mad you think the parents might get, you still have got to report. Really important. So, all right. So we've gone through our parade of horribles. We're going to see if we can work on avoiding having it be your district or you that's in the headlines. So again, back to our 4 keys here. The first being staying up to date on your medical education and standards of care. The second being establishing those working relationships with students and families. And then staying up to date on state and federal laws, as well as documenting your compliance. All right. So just a real basic legal tutorial here. You'll see that this is a pattern jury instruction. So whenever a case goes to court, this is the instruction that a juror is going to read when they're deciding liability on a case. And it's what is negligence? It's the failure to exercise ordinary care. And in this case, it's the doing of some act that a reasonably careful person would not do under the same or similar circumstances. But for you, I would say the issue is, it's more appropriately stated, it's the doing of some act that a reasonably careful nurse would not do under the same or similar circumstances. Likewise, failure to do some act that a reasonably careful nurse would not have done under the same or similar circumstances. You're going to be measured against a reasonable nursing standard as opposed to just a reasonable person standard. In terms of negligence, in order to show that you have been negligent, usually it's going to be a family, right? They've got to show that you owed them a duty, that you breached that duty, and whatever you did to breach that duty caused their student or them to be injured. And then obviously they have to show that the injury or damage has occurred. So what are the sources, or where do we get our standards? What creates a duty for you guys? And the answer is there are a lot of sources of duties. So the first we have is sort of the obvious. You have your state and federal laws. You've also got your local, you've got any local laws and then any district policies. You've got your relevant nursing standards and guidelines from professional organizations and agencies. And remember, you're looking both at the nursing standards, and one of the big issues you guys are going to run into is what is the scope of your responsibility as a school nurse? Because the scope of your treatment does not necessarily reach as far as an RN would in a medical setting. So for example, diagnosing the UTI, right? You guys aren't going to diagnose a UTI. You are going to recognize that there are potential symptoms of a UTI and recommend that the student receive medical care and assessment. So remembering where that scope is. Let's see. Just want to make sure I'm not missing anything. All right. So moving on, I want to talk a little bit about best practices. So first of all, I've said it a bunch so far already, but really important to document. And so you want to document your conversations that you have with parents. You want to document the conversations that you have with students. You want to document your observations that you have of students. You want to document your conversations with health providers. You want to document actions that you've taken. And remember, this includes, so I've got up there, I've got conversations with parents. You also want to make sure that you document any attempts that you've made to contact the parents that have been unsuccessful. So really important to document attempts. You want to make sure that you document any training that you have provided. I also recommend that you keep really good notes on training that you've attended, so that you can say, I've got, I've maintained my my continuing education. I'm up to speed on current trends. Another best practice, getting a witness in appropriate circumstances. So we've talked about, even though the searches that we reviewed and discussed were inappropriate searches, if you are in a situation where a search is appropriate, absolutely get a witness. If you do need to do an examination that is going to be personal and requires that a student reveal private areas, absolutely get a witness. Sharing information, making sure that people who need the medical information, that they have that medical information. If you have a teacher who has a student who has epilepsy in their class and doesn't realize that that student has epilepsy in their class, and that student is having issues and the teacher doesn't have any idea, you've got some issues. You want to get that?
Just like clockwork.
It is.
Every 10 minutes.
Yeah, it just means that I need to move on with the slides a little faster. So, all right. Let's see here.
I have
All right. And then we talked a little bit earlier about training. Make sure that if you are going to delegate certain tasks, A, that they are tasks that you can delegate, and B, that you have provided training to the folks that are going to be doing those tasks. So, all right. So there are going to be a lot of times that you have student interests that conflict with his or her parents. You're going to have students whose needs conflict with the administrator's directives. You're going to have times when the best medical care for a student conflicts with the parent's wishes, right? And those can all be kind of tricky circumstances. So we're going to talk a little bit about trying to balance those interests and priorities, and also what are your obligations under FERPA, under HIPAA, the whole bit. So first things first, your first priority absolutely is to protect the student, and that comes in a lot of forms. Most importantly, you want to know your standards of care, and we're talking on a national, state, and local level. You want to follow those standards of care. This would be your mantra. Know the standard of care, follow the standard of care, document. Know, follow, document. If you do those things, you're going to be in pretty good shape. All right. Yes. And remember that you don't want to provide care that is outside the scope of your license. I talked a little bit about the examination example. My other favorite case right now that just came out not too long ago in Florida this month, this had to do with a principal, not a nurse, but it's as applicable to nurses as it is to principals. We had a principal who was practicing hypnosis on his students. And shortly after these hypnosis sections, he actually had 3 students who died after being hypnotized, most of them by suicide, all 3 of them by suicide. And those, after the 3rd death, the parents got together and said, hey, wait a minute, this isn't right. And so that principal has been criminally prosecuted for practicing therapeutic hypnosis without a license. Also, so in Florida, there is a limit of $200,000 per incident, per death. So the district ended up paying out what is essentially the limit, so $600,000 for these three deaths. But the point being, just because you know how to do something or think you know how to do something doesn't mean that you should do it. Think about whether it is within the scope of your license and whether that is an expectation of you as a school nurse. So you want to look at your district procedures. You want to know what those district procedures are. You want to follow those district procedures. Also, don't be complacent with the district procedures. If you're looking at a district procedure and it doesn't work, you should raise your concerns with your administrators. And I'm not saying that you always need to be questioning or challenging your administrator, but approach your administrator in a collaborative fashion and say, hey, I have concerns about this procedure and I think there's a way that we can draft it so that it works better for us. And try and work through it that way. But don't just look at the policies and turn your brain off. Look at the policies, look at the procedures, and think about how those are working for you in the context of your nursing obligations. All right, delegation. We have talked. This is the 3rd time I think that it's come up, but it's really important. You need to delegate appropriately, and when you're in doubt, don't delegate it. Do it yourself, or make sure that some other nurse in the district does it. Take a look at RCW 28A 210. Really important. It talks about delegation and training and supervision requirements. Specifically, you have section 260 through 280 that applies to administration of oral medication. You have section 383, it talks about epinephrine to students with diagnosed allergies. You've got 290, which applies to catheterization. And then you've got 330 that talks about diabetes health plans, which Callie had covered a little bit earlier today. Let's see. You want to make sure that you check the medication records, and that those are that if you are delegating that task to somebody else, make sure that they are following through and following the medication plan. There have been a lot of lawsuits over failure to provide anti-seizure medications. And then with diabetic students, that's another issue where we've seen, or another area where we've seen a lot of issues. You want to do an insulin check. You want to make sure that your personnel are trained in washing their hands. We've had a lot of issues surrounding diabetic students and glucose checks. Last but not least, you want to maintain student confidentiality. So we'll get into some of the situations that are a little trickier, but just generally speaking, good practice. If you have paper files, keep them locked. Put them in a filing cabinet with a key, lock it, take the key with you. Make sure that the only other people who have access to it are people who need to have access to it. If you keep your records electronically, that's a lot more common these days. You've got to make sure that your computer is secured and password protected. Really important. We'll talk a little more about this in the HIPAA and FERPA sections. So, let's see, how are we doing?
You're doing fine.
Okay, great. All right.
About 6 or 7 more minutes.
Okay.
Is that okay?
Yeah, that's fine. Okay. We've got more material, but we'll get into it. We can cover it pretty quickly. Okay, communicating with families, really important. We've talked about that. Don't forget to log in your attempts to contact parents that are unsuccessful. Remember, you can always advocate for students. You can advocate for family rights. Know that parents generally have a right to know about medical conditions of their students, but know when they don't. For example, STIs, they do not get to know about those once the student is over 14. They don't have any reason to know, and think about that when you're documenting it in either your file or the student's file. Once you document something and put it in the student's file, it becomes an educational record, and that is then subject to inspection by the parent under FERPA. So if you have a student who comes to you and talks to you about an STD that they have, my recommendation to you is if you have to take notes, you can take notes. There's an exception to notes, but those notes have to remain in your sole possession. You cannot share those with anybody else. As soon as they make it into the student file, they become an educational record, and the parent can review the student's file, including that record. So just be aware of that.
Can you say more about that, about what constitutes sole notes? Is it just a file you would keep in your...
And then
Sorry.
no, you're okay. But yes, you're
sure that question's coming. Okay.
So, and I'm trying to get through this a little bit since we're running short on time. So sometimes parents have a right to prevent medical treatment, know what those situations are, and again, do this in writing or note the phone call, document it, really important. Retain your parent contacts, log attempts to contact parents, and again, be mindful of what you're documenting. That's kind of what I'm getting at with the with mental health issues and with especially with birth control, STD, things like that. So under FERPA, FERPA protects education records. Education records really broadly defined. It's any records that are directly related to a student and that are maintained by an educational agency or institution, and that's it. That's all it requires. So parents and students can both access FERPA protected records, and school officials can also access them. They have to have a legitimate educational interest. Pretty much all other disclosures prohibited unless you've got parental consent to release the records. One thing you should be aware of is what the district's annual notification provides, because that a lot of the times will indicate who it is that is a school official and thereby who can have access to a student's records. You've got an emergency exception to FERPA where you can disclose personal health information if there's an imminent emergency, and it needs to be an articulable and significant threat. Disclosure, under those circumstances, you can disclose to appropriate parties. And remember, we'll get into, well, I want to talk a little bit. So an articulable and significant threat, you want to make sure that you can explain why, based on all the information available, a student poses a significant threat to his or herself or others, and why disclosure to an appropriate party is going to assist in protecting a person from the threat. If you can't articulate those, you probably don't have an articulable and significant threat. Also remember that you have documentation obligations. You need to make sure that within a reasonable time, you have to document the articulable and significant threat and the parties to whom you disclose that health information. You also want to place a document in the student's education records about what was disclosed and to whom it was disclosed and why. You don't actually have to provide that documentation to the parents, proactively, but you do have to provide it if they submit a request under FERPA. So HIPAA doesn't typically apply. Schools are not entities covered by HIPAA. We do have a nice new chart that was provided by, I'm sorry I don't have it, but thank you. So it was actually Carlos Chavez at Pacifica Law Group who put together this matrix on behalf of the Washington Schools Risk Management Pool. And I think that Robin either has provided it or will provide it, and I know it'll be on OSPI's website. But it basically sets out if you have a reason for wanting records, it says, here's the type of record you might want, here's why you might want it, do you need an authorization, and what HIPAA and FERPA have to say about it. And then it has some kind of generally helpful comments. So if you have questions about whether you can get records and how you can get them, it's a really good resource for you. I'm not going to get into it because A, it's outside the scope of what we're talking about today, but also we just don't have time. All right. And because I feel like things are getting a little dry. So let's see. So let's talk a little bit here about, this is the treatment records. So FERPA excludes from disclosure and review by parents or students treatment records. So they can't be shared with anyone other than those involved in providing treatment. It's a really limited exception here. And the reason I say that is it has to be something that is retained only in your nurse's file. It can't be in the student's file. And the other issue is it means if it's not in the student's file, if you're gone for whatever reason and somebody needs to, and it's information that somebody needs to be able to access, that's something that really does need to be in the student's file for reference. So information about an STD, I think that's fine to keep just as notes and keep in your own personal records as long as you've done everything that you need to address. So any reports to CPS, anything like that. But as soon as you put that information into the student's file, that is going to become a student record, and it's subject to review by the parents. So just think really hard about what you're disclosing or what you're putting in the student record and why. And also think really hard, if you're going to keep something only in your file, think really hard about whether keeping that information is potentially harmful to the student because other people might not be able to access that information. So, does that address your? Okay. Okay, general take home, FERPA is going to apply. Typically, HIPAA's privacy provisions are not going to apply. It is okay for a hospital, a treatment provider to share information with a school. School nurse is a healthcare provider. You're entitled to information. With the exception of STIs or STDs and mental health services. That information needs to be specifically released. Doesn't work the other way around. Once you guys have the information and it's in the student records, you have an obligation to protect that information from further dissemination and disclosure. All right. We talked a little bit about you've got special protections for STDs or infections under the RCW. 2 minutes, great. I just want to make sure that I get to the most important parts. All right. Yeah, let's talk a little bit about preserving privacy. So again, all the records need to be related to a student, need to be protected under FERPA. If you have gossip, as long as the person who has access to the records is not the source of the gossip, it's okay. If you have a student who is self-advocating because they have a food allergy, that's okay. That's an okay disclosure. It's just if you are the person who is receiving information through the student record, you cannot just redisclose that information. You cannot redisseminate. So in terms of transgender students, there's been some controversy that's come up in some districts where a transgender student's parent has insisted that the student's wishes not be accommodated. So you have a student who is transgender, but the parents are refusing to recognize that. My recommendation at this point has been to keep the legal name of the student and the gender on the official paperwork, but to refer to that student in class time by their preferred pronouns and by their preferred name. Also, just as a reminder, general rule, we treat transgender students as by their identified gender, and that includes locker rooms, it includes bathrooms, the whole bit. So, all right. Remember, you've got a mandatory duty to report sexual and physical abuse. You've got to report neglect. If you have a public health emergency, if you have a measles outbreak, OSPI has some really good guidance on this information. You have a mandatory obligation to report. You also have a mandatory obligation to cooperate with your public health officials if you have influenza outbreak. So it's good to be in touch with and have a friendly relationship with your public health officials anyway. This is just one more good reason to have it. You've got a duty to report when you've got to protect the health of the student and when your school policy requires it. So that's an issue where if you have an accident or an injury of a student, you want to make sure that the folks in PE, that all the students' coaches, and to a certain extent teachers understand what those injuries are and what the limitations are. So, all right, we talked about mandatory reporting. Okay, and I want to cover these two, and then I think we'll go ahead and be done. So there are specific issues relating to privacy and reporting concerns for sexually active students, right? So under this RCW, you can't disclose the identity of anyone who's been tested or treated, and it protects the release of test results. And for you guys, this shouldn't be a tremendous concern in terms of sharing information, because hopefully this student is not in a position where they are going to be sharing their STI with anyone else while they're on school grounds. If that's happening, we've got a whole bunch of other issues that we're going to have to deal with. Same thing with abortion and birth control. Decision to release that information rests solely with the student. So just, again, be aware of that information and be aware of what you're documenting and what's going into the student's file so that you can protect the privacy of your student. Do remember that if you've got a student who is underage or who you suspect has an STD and continues to vehemently deny any sexual activity, that should be a red flag to you that maybe you need to consider whether it's a mandatory reporting situation. And you've got to trust your judgment and whether you've got a reasonable basis for making that report, but just something to be aware of. And then let's talk a little bit about mental health concerns. Remember, mental health treatment is outside the scope of your practice. However, you are very frequently going to be the first line of defense. And so it's really important to know what your district, to recognize that there are going to be times when you need to be able to say, these to me are signs where this student may need treatment or may need assessment. And that's a good time to get your counselor or your psychologist involved and make sure that you are referring that student to potential additional resources within the community, especially because a lot of times with mental health concerns, you're dealing either A, with an issue that the student doesn't want to share with their parents, or B, potentially with suicidal ideations. And then you've got a whole additional slew of requirements in terms of following the district's plan. You know, back in, I think was it 2013 or 2014, beginning this, actually the 2014-2015 school year, schools are required to have a plan for recognition, initial screening, and response to emotional or behavioral distress in students. So you really need to know what that plan is. You need to know what the, pay attention to the warning signals, adhere to those protocol, and know what the district expects you to do and how to respond in a crisis situation. And that will help you avoid liability from a professional standpoint, and also as for the district as a whole. So again, be careful.
Hello, everyone. We're back. So I guess the way we can do this is do kind of a round robin, and we'll start with the ESDs that did not get called on during the question period with Callie. So let's start with Spokane. Spokane, do you want to share with everyone sort of what your thoughts were on the first case concerning Fred Jones, our 15-year-old kiddo? Spokane? Hello? Okay, let's go ahead and try Anacortes, ESD 189. That's Lorelei.
Hi, Robin. This is Anacortes. We do have a comment. Hang on.
So we decided that the health room aide, who probably normally gives him that medication every day anyway, should be the one that gives him that medication. And then we're not going to worry about him being late later on because he's already had his medication on time by the person who routinely gives it to him anyway, since we're only in that office once a week anyway. That was our decision.
Don't disagree.
Anybody else? No? I think that's it from us, Robin. Thanks.
Okay, great, great. How about Puyallup? We haven't heard from Puyallup yet. Puyallup.
Good issue spotting by Anacortes.
Okay.
Okay.
Is that Puyallup I hear? How about Vancouver? Maybe I better call Tony.
Yeah.
Robin? Hi, Robin.
Hi.
So we discussed it as a group already, so I don't know, does anybody want to add anything to, any questions, anything? No, I'm not getting any response here, so. We're all good.
There were other issues, you know, besides just Fred Jones. I mean, on this same day, so Velma Dinkley comes in, you know, with clearly an urgent, probably an STD, and says that she's going to kill herself. And I didn't hear that addressed yet. And the questions are, what do you do? Who do you call? What do you tell them? What do you do afterwards? And how do you resolve the issue for the future? Can anyone sort of summarize that process that you went through? Want to share your thoughts on how you would respond to that situation? I'm just gonna, people, just sort of open it up. So, you know, at any of the sites. Oh, go ahead.
Yeah. So we were going to ask, got a plan. Suicide part of it. I don't know if there is. I don't know what's going on. Should you hear it? No.
So is there someone from another site who would like to share their thoughts?
Somebody other than us.
All right, let's try ESD 113, Tumwater. Anyone there have thoughts to share?
We have some questions.
Is it
we had some questions in Spokane.
Great, great.
Hooray, question.
Yay.
They asked if there's any questions.
Okay, so I think we're still kind of in the process of discussing the issue, but with the threatening to kill herself, we're mandated reporters, correct? And so that piece we would have to report. That's
I don't know that you. No, I don't think that you are necessarily at a point where you need to report. I think this is a situation where I would probably refer your, this falls under the counseling rubric. So my suggestion would be at this point that you refer her to your school counselor, assuming that the school counselor is available, and have the school counselor do an initial assessment to determine whether this is something that needs to be reported, whether this is something that falls under whether your school plan to address suicidal ideation or not. Like, you know, this could have just been an off-the-cuff comment. She may not have access to self-harm. She may not have any issues, and that's certainly more within, I would say, the scope of your counselor. And so, you know, part of your role as a nurse, from my perspective, is making sure that you're referring a student to receive appropriate services. And specifically in this case, with a mental health issue, I would refer it to the counselor.
Yeah.
And follow through, right? Making sure the student actually meets with the counselor.
Yes, absolutely. And document.
Yeah. And so our other question was about the frequent urination. That issue with letting, I mean, how far can the school nurse go in letting the teacher, for instance, know that that student needs to be excluded or excused from class to use the restroom until the symptoms resolve? Is that a violation of the student's privacy? I mean, how would you handle that?
I think that you can have the discussion, so you need to have the discussion with the teacher. I think that you can have the discussion without disclosing a specific medical symptom. So you just say, hey, look, I've talked to this student. When she says she needs to use the bathroom, she needs to use the bathroom. You need to allow her to do that. End of story. You haven't disclosed personal health information. You've just said, when she says she needs to go, she needs to go. Done. And if it becomes an issue, I would talk to the student and say, if you are continuing to have issues, please come and talk to me, because I think that probably the student is going to be more comfortable doing that. And you can figure out how you need to address it if you continue to have issues. But as an initial intervention, I think that should be sufficient.
Yeah, I think our question on the mandatory reporting was more around if she's complaining of the STD. Oh, I'm sorry, I didn't know. I thought you had it muted.
Nope, go ahead.
If the student that was complaining of the STD doesn't want her parents to be aware, obviously we'd already refer her based on what she said to the counselor or the mental health or whatever was in our school that initiates, the piece about what she had said about killing herself. But as far as the STD and getting her help that way, if she didn't want to actually tell her parents, then we would make referrals for her for Planned Parenthood or doctor or whatever it is that follows. But if she didn't follow up with that, do we have a response after she doesn't follow up? Would we have a response at that point to report to potentially mandatory reporting to CPS about that particular condition? And how would that work?
I think as long as it's not a life-threatening condition, I don't see it as a mandatory reporting situation, as long as you don't suspect any abuse. I mean, if she's sexually active, she's sexually active, and that's her business, unless you suspect that Shaggy is 25 and she's 16, and then you've got an issue, right? So that's one of the issues that you want to look into that we haven't discussed is, how old is this Shaggy character, and are you dealing with a statutory mandatory reporting issue in that respect? In terms of getting this student treatment and the insurance issue, that's one of the times that I would recommend. This is one of those situations where you want to know what your resources are in your local community, and is this a situation where you can refer her to a doctor that will provide treatment without insurance payment, without talk to your public health officials and figure out what your resources are. And see if you can get her referred someplace where she's not going to have to fork over her insurance information in order to receive treatment, diagnosis and treatment.
Thank you.
Yeah.
I think I'm going to go back to ESD 112. They were trying to talk with us and it didn't come through. So back to you, 112.
All right, I think we've already covered what responses we had here. Anybody else want to add anything? Are you unmuted?
Yes.
Okay.
13 has something to say.
Okay, let's go to 113, please.
Well, we just thought you were desperate for an answer, so we were just going to give you a contribution.
Great.
One thing I laughed said, well, poor Fred Jones that didn't get his medicine when there was a really issue at that moment. I think I would have given Fred Jones his medicine so that he wasn't anywhere near the health room to hear any of that conversation. And he would have had his medicine on time and it would have protected her privacy. But second of all, should we jump to the conclusion right away? She has a sexually transmitted disease. I mean, I think that we could have said, you possibly even have a urinary tract infection, and it's important that you be seen, especially if you're having a lot of these symptoms and discomfort. If you have a relationship with her, you certainly would probably want to talk to her about preventing sexually transmitted disease if she's admitting she's sexually active, even though she's on birth control. But I think just maybe under the guise of going in to rule out urinary tract infection as an option and encouraging her. I did agree with, and we talked a little bit about referring to the counselor also. But, it isn't life-threatening. I don't think we're a mandatory reporter in any circumstance like that, but you would certainly want to encourage her to care for herself.
Right, exactly. And, the big issue is just making sure that she can receive any potential diagnosis and treatment that she might need, whether it's a UTI or whether it's an STI, without disclosing to her parents that she's seeking this type of care if she doesn't want her parents to know. In terms of the administration of the medication in the first place, I think the nurse who was presumably planning on administering the medication, for whatever reason, needs to just take a quick break, even though Velma is bursting into her office. You need to, I think, take a quick break, make sure that Fred Jones is taken care of, and yes, by the person who typically administers his medication when you're not at that school. and then take a moment to go ahead, close the door so that Fred and secretary are not listening to this private conversation that you are having with Velma. So, making sure that you don't allow Velma's panic to create your own, to adjust the way that you deal with the situation. So you've got to take control of that situation. Closing door, good. Yeah. Thumbs up.
So any thoughts, comments from anyone regarding case number 2?
Well, actually, 105 in Yakima, we have a little something to say.
Yeah, go for it.
I'm a nursing student doing my public health rotation here, and I just had a couple things to say. So I think we would give the medication to the child first, and ask the student that just rushed in if she could just wait in the other room for a little while you administered that medication. Call the staff and let them know you're going to be late to that IEP meeting, just so that you're being part of the team. Then you could discuss with the student about possible resources like Planned Parenthood and Here Life Choices. Since we don't diagnose and we don't know that she has a UTI, we wouldn't go straight to saying, I think you have a UTI, because we don't diagnose. Although, if we're talking about scope of practice, a suicide assessment is within our scope of practice, and we could do a suicide assessment without referring it to a counselor. You can do it by the SLAP method or various other suicide assessment tools, because this could just be a reaction of her being stressed out. She could also go to any ER in the state and not give insurance information to be tested for sexually transmitted disease or infection. We could also provide safe sex education, document that in a private file, and then provide education to the teacher about proper child development, since maybe he might be a little foggy on allowing children to go to the bathroom.
Thank you, Carmen.
Wow, what a great student. You are doing your studying. Thank you.
No, all good comments. There are a lot of folks in this scenario who could use training. You've got a secretary who is just shrugging, saying, I don't know where that student went. That's somebody who could use some training. And in our potential asthma situation, you've got a teacher who's saying, you're just out of shape, suck it up. That could use some additional training. Yeah, all of those things. Anybody else?
Well, Spokane has a quick question about scenario 1.
Okay, I was just asking, I work at a high school, and I have sort of that situation that happens in scenario 1 quite a bit with just students coming in with, issues, stomach issues, and we know that there's a ton of different things that could be. It could be related to it could be related to a number of things, and we don't diagnose. But my question is this: after you go through all the assessment process, and they've told you they're sexually active, and yes, there's a possibility they could be pregnant, yes, there's a possibility, whatever, and you want to seek medical treatment for them, is it appropriate to? Because as far as personal health information, this is where I usually ask my students, what do you want me to share with your parents? If you want me to, because they're wanting to go home, they're wanting parents to come pick them up, take them to the doctor because they don't feel good. So what information can I share with your parents, or do you want to share with your parents? And if they give us the okay to do that, should we have that in written form? Like where are we in that process of being able to share that information if they give us a verbal consent to share that information with the family, like symptoms and whatnot, and we think that they should be taken to the doctor, that kind of thing?
If you have consent from the student, I would go ahead and document that you received consent from the student. Okay. And I think you can put it in the student's file. If the student is not expressing concerns about about their parent knowing about their symptoms, then the more information you can share with the parents, the better, because that's going to increase the likelihood of receiving appropriate treatment.
But liability-wise, we'd be okay because
instead of getting written consent from them that says, yep, it's okay to share this with my parent or whatever, if we just wrote a verbal consent and it came back to us as later as the student said, well, no, I actually didn't tell them or something like that, then where would we be? Would we still be covered as long as we documented that we were given verbal consent to share this, this, and this information?
I think you have to look at the type of information that you're sharing. So if you're sharing information that you think is potentially, STD or mental health information, then I would go ahead and get a written consent from the student. If you are sharing that their stomach hurts or they're having, they have a headache and they have tingling on one side, so you're thinking that, maybe it's a migraine or there's something neurological going on, then I think you're fine just having the verbal consent. But I think you want to think about what kind of information it is that you're receiving and sharing.
Right. Okay, thank you. That clarified.
This is ESD 114. May I hop in?
Hi, please do.
Hi,
Hi, Judy.
Hey, Robin. I wanted to say something about Velma, which is indeed her symptoms are indistinct and could be, not STD or pregnancy related. And if she was going to go to a clinic, she would actually, they would have to have consent from the parent to treat her if they suspected that her problem was not one of these other problems. So just so you know, if you're going to send her to the STD clinic, hopefully they're on top of things and don't miss what could be a real medical emergency. And so I just wanted, because a lot of people maybe don't think of it that way, but she might go in for that STI assessment and really have a serious, like, kidney infection or something like that, which she does need consent from her parents if she went to a clinic. So
and hopefully whoever you're referring her to would recognize there are additional symptoms here. You need to go seek additional care.
And also, from one of our larger districts here, for students who have issues, and let's just say Velma is somebody who has, and I don't want to get too far afield, but has urinary tract issues, is having issues with the teacher not letting her go to class. If you have a student who maybe has a problem like that chronically, they actually do year-long passes for a student like that. So I just thought I'd throw it out there because I thought it was a good idea. And so anyhow, I'm just putting that out there. So anything else there for 114?
Robin, this is Gail in ESD 105. I just wanted to connect with both of you. First of all, thank you. It's been really informative and a bit scary, I have to admit. I'm sure not just ESD 105. We didn't get to ask any questions because of the time situation, but I tried to email all that were given to me. Is it possible that we could have them looked at and that you could share the ones that you think are relevant, the answers, that I can get back to the nurses at ESD 105? Thank you.
No, absolutely. In fact, we can actually do that now. So one of your questions actually applies to one of the case studies. A situation came up with a homeless student having asthma needing an inhaler, and hers was empty. I had many suggest use of inhaler and cover due to distress. One student's family has brought 3 inhalers in for a student that rarely has need. So that is what they were referring to. Mom was in Seattle. Can there ever be a time to use another's inhaler, or do I just call 911? Much pressure from staff, as they have been doing in years past. Help.
So I would do 2 things, I think. First of all, yes, I would continue to call 911 because you don't want to use another student's inhaler, even though that's a tempting circumstance. And the other thing is that this may be a situation where you can do a 504 plan and get the student assessed medically. It would be on the district's dime, but you're looking at a situation where this student
it's affecting a basic life function, right? Ability to breathe. So I think that's maybe how I would try and address the situation. But that's a tough one. Do you have additional thoughts on it?
Well, no, I think that's a good answer. I think that's a good response. There's another couple of questions from ESC 105. One is there's a situation where a teacher was passing medications to students without having received delegation training from the nurse. Apparently the parent and teacher worked this out. The teacher was aware of the district's policy. And so what can the nurse do in the aftermath when that has been discovered?
Well, so yeah, that's a situation that's got to be remedied. And I think this is a situation where you're going to attract more flies with honey than the alternative. And so I think that what I would do in your situation is I would talk to, I would try and have a group meeting and discuss it as a whole, try and get a better system in place. And you've got to it's going to be a little bit political, frankly. I mean, you've got a parent and a teacher who are very happy chugging along and doing what they're doing, and it's working for them. But, I think if you approach it correctly and in a collaborative spirit, you can get an appropriate plan in place where the student is coming to the office and receiving medication from somebody who has been appropriately trained in distributing that medication and keeping appropriate documentation, because that's the other thing that comes to my mind is I could almost guarantee you that teacher is not keeping a nice thorough log of when and how much medication has been distributed. So.
Yeah. So another question, what about diaper changes at school? Would it be an issue if you can't reach the parent by phone if it isn't part of a student care plan? That was from 105. Does the person who asked that question want to elaborate?
Yeah. No. Anybody?
Okay.
No? Okay.
It is after 4 o'clock now. It's 4:03, and I want to respect everyone's time and thank you very much for your time and your attention today and your excellent questions. So if you do have remaining questions, and I have a number of questions that were submitted after Callie's presentation, I will compile all those and send them to both Callie and Emma, and we'll get back to you with responses on those. If you have lingering questions now pertaining to Emma's talk or anything that came up in the case study or anything in your own practice, please go ahead and send those and we will get back to you on those. A final note is all of you, based on your sign-in sheets and the email that you provided on those sign-in sheets, you will be getting a link to complete an evaluation of today's event, and once you have completed that evaluation, your clock hours will magically appear. So thank you very, very much. I appreciate all you do every day for our students.